Today, we are deliberating on a very, very important judgment under SARFAESI law. This judgment is having a citation as Canara Bank versus State of Madhya Pradesh and others. This presentation analyzes how the High Court of Madhya Pradesh has held that the bank cannot evict an occupant, cannot evict a borrower from the property after auctioning it. The judgment is dated 30th of January 25, but then we thought that there are many banks. They do not take physical possession of the properties of the secured assets, and they sell the secured asset on symbolic possession. And thereafter, they invoke Section 14. They apply to the additional district magistrate or CJM or CMM for physical possession of the property. They all have to be very, very aware of this judgment. And in this judgment, it was the petitioner was Canara Bank, and then the respondents was the State of Madhya Pradesh, District Magistrate Indore, and Tahsildar, and the borrowers and the occupants of the secured asset, mortgaged asset. The bank, in their application, sought the directions from the court that to implement the order of the additional district magistrate for evicting the occupants under Section 14 of the SARFAESI Act. And that they actually did after the sale of the asset. After taking symbolic possession, the bank sold the asset, and thereafter the bank applied. In fact, the story started long back in 2019 when an essay was filed in DRT, and then the DRT granted some interim relief, and also the ADM passed an order under Section 14 for physical possession, and also thereafter DRAT allowed some relief, but the bank in fact sold the asset in 2023 while the asset was in symbolic possession with them. And on 30th of January 2025, this judgment was delivered by Honorable Madhya Pradesh High Court, and the argument which was presented by Canara Bank, the petitioner, that the borrower had taken a loan of say 13 lakhs of rupees. The bank initiated SARFAESI, obtained an order from ADM, and then the bank claimed the right to seek assistance from the state authorities, local authorities under Section 14 of the SARFAESI Act, even after the auction of the asset to a third party, even after the sales certificate was issued in favor of the third party respondents, the borrowers. What they argued before Honorable High Court, Madhya Pradesh High Court, was the property was already sold. The bank is no longer a secured creditor. The bank surpassed some kind of interim order also, but the primary argument was that Section 14 is applicable only on secured assets. And when the asset is sold, when the sales certificate is issued, when the full consideration is received by the bank, that the bank is no more a secured creditor. This particular asset is not a secured asset. It is not a security interest of the bank. So therefore, the Section 14, the assistance of the state or district authorities is not applicable. So that is what is the argument of the borrower or the occupant of the property. Now, what are the issues involved? One issue, can a secured creditor, that means bank, Canara Bank, seek physical possession after auction of the properties under Section 14 of the SARFAESI Act? Second, whether assistance under Section 14 can be sought after the sale of the asset. And third, of course, the bank is obtaining a writ order by suppressing some of the facts. Now, the court relied on Section 13 and Section 14 of the SARFAESI Act, Article 226 of the Constitution of India, and the judicial pronouncements. The observation of the court was very clear. The court observed that the secured assets had already been sold by way of auction, and sales certificate has been issued after taking full consideration. Therefore, the bank was no longer a secured creditor and the property was no longer a secured asset. The auction purchaser had become the owner, and the bank could not seek assistance from the respondents to evict the borrower. The bank cannot seek assistance from the district authorities under Section 14 of the SARFAESI Act, because that particular assistance is applicable on secured asset when the bank would be a secured borrower, when the bank is no more a secured borrower, no more bank is having that secured asset. Court also found that the bank also some kind surpassed or suppressed some of the facts in this case. So therefore, the court, in fact, finally the judgment was the writ petition dismissed. The section 14 is not applicable. The bank cannot take assistance of the district authorities, state authorities for taking possession. And now this impact of this case on SARFAESI actions, very, very important. The banks and ARC, they must complete possession under section 14 of the SARFAESI Act before sale of the asset. Post sale, the right to evict possession to the auction purchaser, not the bank. That right is with the auction buyer, not with the bank. An auction buyer can only take action under the civil remedies, not under section 14 of the SARFAESI law. So all the legal advisors to the banks, they must know that this kind of judgment will be used by all those borrowers, all those occupants, when they feel that the bank have sold their properties after symbolic possession and not after physical possession. So therefore, this practice of selling the assets of the secured assets of the banks without taking physical possession will end till this particular judgment of High Court of Madhya Pradesh is challenged in Supreme Court or it is stayed in Supreme Court. Thank you very much.